This is Law Bites, a podcast with Michael Geist.
We have a case to hear this morning, so I will call the parties now. In the case of Canadian Copyright Licensing Agency against York University and between York University and Canadian Copyright Licensing Agency.
The Supreme Court of Canada recently brought a lengthy legal battle between Access Copyright and York University to an end, issuing a unanimous verdict written by retiring Justice Rosalie Abella that resoundingly rejected the Copyright Collective's claims that its tariff is mandatory, finding that it had no standing to file a lawsuit for copyright infringement on behalf of its members, and concluding that a lower court fair dealing analysis that favored Access Copyright was tainted. The decision removes any doubt that the Supreme Court remains strongly supportive of users' rights and vindicates years of educational policy in shifting away from access copyright toward alternative means of ensuring compliance with copyright law. Kim Nair is the Edward Cornell Law Librarian, Associate Dean for Library Services, and Professor of the Practice at Cornell Law School. She appeared before the Supreme Court in this case, representing the Canadian Association of Law Libraries as an intervener. She joins me on the podcast to talk about the Access Copyright York case and its implications for the future of copyright, education, and collective rights management. Kim, thanks so much for joining me on the podcast.
Oh, thank you, Michael. It's a pleasure to be here.
Yeah, no, it's great to have you on. And it comes, I think, at a really notable time. As you know, of course, one of Canada's longest running copyright sagas came to a close late last month as the Supreme Court of Canada issued its decision in the York University Access Copyright case. Court certainly didn't waste any time. The ruling came just over 2 months after the hearing, and the unanimous decision was written by Justice Abella. And this case was, of course, the last case she heard on the court before her retirement just at the end of June. Now, I'd like to get into the Supreme Court decision, but there may be some listening that don't have a lot of familiarity with the case. So why don't we start a little bit with the background? You know, what is access copyright and what led us to the point that it was locked in litigation with York University?
Yeah, it is an interesting background and a long-running case, and it basically sort of encompasses my joining the post-secondary sector from legal practice prior to that. So Access Copyright, it's a collective licensing society that arose out of something that was earlier called CanCopy. And that was a solution essentially to compensation for a wide range of copyright holders for copying by universities or people in universities. So CanCopy arose in an era that was where a lot of paper copying was done. And it was also a different era of library acquisitions. So the materials that libraries held for universities were largely in print format. So really it was an efficient way, I think, that both CanCopy and subscribing or participating institutions found to be an efficient way of clearing permissions at then what I understand was a reasonable and representative cost for the participants in the collective licensing tariff arrangements, using negotiation and board approval for a tariff. So that's the background of Access Copyright. And I don't speak on behalf of York, of course, but I'm aware that from my own having been in a post-secondary institution in Canada in a library at the time, I'm aware that many institutions did begin to have difficulty with that collective licensing regime, the collective society tariffs. And at a point, I think about a decade or so ago, the rates for licenses increased dramatically per student. And I think the numbers at the time of the conclusion of the last tariff was something like $3.38 a student. And then there was a small amount per page for courseback fees. And that went up to a blanket license of a blanket fee of $24.80 per student. So a big jump. And that's around the time that I actually joined the post-secondary sector. And that was a big topic of conversation. but at the same time, when you look at it from the university perspective or the library perspective, and of course I work in a library in a university, and I did at the time as well. Universities were subscribing to their resources through other means than the repertoire that was covered by the access copyright regime. So some were using different consortia and aggregator licenses for electronic resources. Others were working directly with publishers or copyright owners for electronic format materials. So they were already paying license fees for different kinds of materials. And then at the same time, the influence of the CCH decision back in 2004 began to become better understood. And educational institutions and their libraries began to think about fair dealing and developing guidelines to ensure that dealing or copying was done fairly in compliance with fair dealing rights in the Copyright Act. In developing those guidelines at the time of this case, they could also look at new educational provisions that were added to the Copyright Act in 2012.
Okay, so a lot of change taking place. Some from within the law, certainly with the CCH case, but but I'm really glad you referenced the change in the way that materials were being accessed, the emergence of digital materials in particular, so that there were alternatives along the way, and that many institutions were finding those to be a more cost-effective, perhaps even a better just way of accessing materials that were needed on campus.
Yeah, absolutely. Absolutely. It just became a huge part of the way universities were doing business to acquire resources. And, as somebody who worked directly in the library, I was really well aware of that distinction and the growing irrelevance actually of the repertoire.
Yeah. So universities are paying for materials; they're just not paying it through the access copyright license. They're also developing these fair dealing guidelines. But obviously, access copyright isn't happy. They want to see payment. They go to the Copyright Board. Can you talk a little bit about that process of the Copyright Board, which of course then leads to the tariff, and York ultimately saying, "We've got these alternatives. We're not paying this particular tariff."
Yeah. So that was. And the institution that I was with at the time exited that process pretty early. But from what I understand, that process of the tariff at the board was not that was not really something, again, for all the reasons that we talked about. The institutions, the universities were not finding that to be reasonable. It was not a system that they wanted to really participate in any longer, given the modern way of acquiring research materials. So, when it came to that tariff, it was something that many universities just looked at and decided to walk away from.
Yeah, so universities walk away. The board does go ahead and set a tariff, though, really without the universities.
Exactly. Yes.
The universities, though, and the universities don't pay. Access Copyright files a lawsuit saying you're not paying, you're required to pay. York responds, as I understand, arguing that they've make a counterclaim, effectively saying that their guidelines that they have developed help address some of these issues as well. Is that essentially what both sides are arguing?
Yes, and so the access copyright's position is that whether York or any other university had actually exited an agreement or didn't participate in a tariff setting process, it didn't really matter. The context of the collective licensing provisions in the Act, as well as the board actually setting a tariff from access copyright's perspective, that meant that any educational institution that was copying any works that were in its repertoire, those institutions were bound by that tariff. And then York, and I think other universities that were not actually part of this litigation, their position and their view was that they couldn't be bound by it. They chose not to participate. They did not agree to participate in that tariff. And they still, as we said earlier, they subscribed to other resources through other means. If they happened to reproduce works by authors in access copyright's repertoire, they could do so by seeking permissions with those authors or with the owners of those copyrights, or they could rely on fair dealing, or they could choose on a voluntary basis to perhaps enter the tariff, but had not done so. So that is what underlay York's counterclaim for the fair dealing position. They wanted to assert this right, that fair dealing continued to cover the kinds of activities, whether or not a tariff existed that others might have been bound to or had agreed to, but that such a tariff not being mandatory upon them in their position didn't override any sort of fair dealing, and that universities had done a responsible action in developing fair dealing guidelines to help the people who were actually doing the copying to understand what the scope and bounds of fair dealing were, as interpreted, as provided in Section 29 of the Act, and interpreted in the subsequent Supreme Court case law.
Sure. Okay. So that's helpful. So we've got, on the one hand, access basically saying you don't have a choice here. Once the Copyright Board set a tariff, you must effectively be part of this. They say as long as something triggers use of the repertoire you're in, York's, for one thing, saying that can't possibly be right. You can't force a license on someone in this way, and certainly not trigger it in a way that now everybody is subject to it in the way that you're describing. But beyond that is arguing they're acting responsibly. They are licensing in a number of different ways, and they've established what they believe are fair dealing guidelines that are consistent with what the Supreme Court of Canada has had to say. Before we get into what the courts have had to say as we transitioned from the lower courts into the appellate courts, one of the things that is often raised, especially when it comes to lobbying the government, is to say that much of this case and even the issue more broadly around educational copying stems from the reforms in 2012, the addition of education as a fair dealing factor. But if I take it from the way you're describing it, this really predates in many ways what we saw in 2012, both with respect to the CCH case as well as the evolution in many ways of how materials were being accessed.
Yeah, so that's always been my view on the matter. Just looking at the relevant cases, CCH really confirmed the user's right in reproduced material. It set out a multifactorial test, which underlies the fair dealing guidelines that many institutions use. And that was the law in place when the Alberta Education and Access Copyright case was decided, which supported the copying at issue in that case was by teachers for the use of students. That case reiterated the user rights focus of CCH. So copying in the educational sector was permissible on the basis of fair dealing user rights in Section 29 as interpreted by CCH. So the legislative reforms of 2012 obviously could not have been considered in that Alberta education case because they hadn't yet been enacted. They didn't exist at the time of the activities that gave rise to the litigation there. The provisions that essentially might have been an issue had they existed are in a few provisions. The educational copying sections, I should say, are highly specific, but there is 30.02, 30.03, and perhaps 30.3 are the sections that really would have some implication in a case where there's educational copying in the context of a tariff or a collective society. So I think this case really was, I think a lot of people were looking to it to find out, if we set aside for a moment the tariff question, or in a hypothetical situation that the tariff did apply, how would these new sections, how would this kind of conduct engage the interpretation of these new educational provisions? And so, honestly, when I looked at the situation and the wording of the sections, I'm not certain how much the 2012 reforms really are implicated in the matter. But that's, I think, what many people were looking to this case to find out, is how did those two things intersect?
Sure. No, I think that's fair. I mean, it is notable that so much of this predates that, particularly given a lot of the noise that we've seen around that particular reform and calls to scale things back within the act. Mm-hmm. Okay, that's really useful background, why don't we jump then into the case? The first stop, of course, is the federal court. We just been describing access copyright, alleging infringement, saying that fair dealing, that the works weren't fair dealing. You've got to pay the applicable tariff. You are counterclaiming by pointing to both the licensing they've got as well as fair dealing, and in particular their fair dealing guidelines. What does the federal court decide?
So the trial judge, the federal court, agreed with access copyrights theory and found that York's activities in copying did actually engage the tariff. The court also dealt with York's counterclaim and found that its activities didn't constitute fair dealing under Section 29. And they also found that the guidelines, at least the guideline that York had in place at the time, also didn't comply with Section 29 or the fair dealing provision of the Act.
Okay, so slam dunk win for access copyright. I remember posting about it, and it was quite clear that the trial judge there was convinced by access copyrights arguments and didn't have much sympathy for York's positions. The case, of course, is unsurprisingly appealed. I think it's fair to say either side would have appealed. This case always seemed destined. This case always seemed destined to the Supreme Court, no matter what the outcomes were.
Absolutely,
in those lower court decisions. Fair dealing, of course, is still a big issue at the Federal Court of Appeal. But the question about the tariff and its mandatory, whether or not it can be mandatory or not, really emerges as a huge issue. And Ariel Katz, who was on this podcast some time ago, talking about that Court of Appeal decision, had done some really exceptional research, kind of unpacking the origins of these provisions and identifying or making the case that, in fact, it was simply never envisioned that they would be mandatory. Can talk a bit about what the Court of Appeal has to say and how they really picked up on Katz's research in that outcome.
Oh, absolutely. So Ariel Katz, Professor Katz, he did some really good work in a couple of pieces in the Intellectual Property Journal, as well as his blog. I heard him on your program as well, speaking about this. But yeah, so the Federal Court of Appeal, they took pretty much the opposite view. They really did rely on that scholarship. They rejected the mandatory theory. Their holding was essentially that if a user chooses not to be licensed under a tariff, yet then makes an unauthorized use of a work, that use is not governed by the tariff. Instead, the remedy is an infringement action. So, if when a user not covered by a tariff does the kinds of things that we've already talked about, looks to fair dealing, ensures that its copying was covered by fair dealing, or is otherwise covered by some other license or direct permissions, then they're on side. But if they're not for any reason, or if a copyright holder believes they are not, the remedy is an infringement action. Access copyright, the way it's structured and set up, they don't actually represent individual authors. They're a license for reproduction of a repertoire of authors' works, but they cannot assert an infringement action on behalf of an author. They don't actually own any of that copyright. So, and they're not an assignee. They don't hold an exclusive license to that work. So that was, the basis on which the federal court said access copyright doesn't have the ability to prevent York from making any copying or to seek reimbursement. So it essentially disposed of that issue by subscribing to the voluntary versus mandatory tariff theory.
Okay, so on that side, they pick up, as we were saying, on the Katz research. It's not mandatory, but they do on fair dealing. Largely uphold what the federal court, what the trial judge had to say.
Exactly, they did, and so they would delve into that fair dealing question, and did establish or did find that York couldn't make the fair dealing case, and also couldn't make the fair dealing case with respect to its guidelines. So they did not grant that declaration that was sought.
Okay. So both sides now, of course, have reason to be unhappy. York on the fair dealing issue, access copyright on the tariff and whether it's mandatory issue. And so unsurprisingly, now we head to the Supreme Court of Canada. There was a hearing in May. So as we're saying, all this has moved really quickly once from the stage of hearing till the outcome, where these are the issues that are largely litigated. And you add to the mix a very large number of interveners, really large numbers on both sides.
17 in total, I think.
It was quite amazing to
Yeah.
see one after another
Yeah.
come through, with a whole series, of course, arguing positions that were sympathetic to access copyright, and then a whole series that were sympathetic to York and the educational perspective. You appeared as an intervener on behalf of the Canadian Association of Law Libraries. What was your focus?
Yeah, so I should also clarify that when it came to the Supreme Court, it was in the format of two appeals, right? It was York appealed from the decision below, and Access Copyright appealed from the decision below. And the Canadian Association of Law Libraries decided not to participate in the mandatory tariff question. Our association includes law libraries that are part of the educational sector, for certain. That's a large percentage of our members, but we also include law libraries that are not in the educational sector, and so for whom the tariff is not really relevant. The other thing, frankly, is we knew that was being quite fully addressed by other interveners, as well as, of course, by York. So our focus was really, our members are law libraries and people who work in law libraries, and we were concerned about the kinds of materials that law libraries hold. We were also concerned about access to justice and whether a narrow construction of fair dealing, something that retreated from CCH and did not, was a retreat from the user rights focus, whether that would be harmful for access to justice, whether that would be harmful for the ultimate users of the materials in law libraries. And we also wanted to get a sense, to make a case for guidelines, not specifically York's guidelines. We didn't really want to speak to the merits of that. We wanted to make a case that guidelines are really helpful. And, as someone who works in and directs a law library, I know that it's not lawyers, it's not university counsel who are standing there, making an assessment of whether a particular dealing is fair. That's not possible. It's library staff, generally speaking, who are doing the copying, and we need to supply guidelines. It's really important for us to be able to ensure that copying is done fairly. And we want to reiterate the importance of guidelines in general as a way to achieve that, and that it's consistent with the holding in CCH. And then, fourth, overall, we just wanted to ensure that the court was aware about, the prospect of unintended consequences should fair dealing be retreated from or narrowed in the kinds of materials or the kinds of use that could happen. So again, we didn't participate in the access copyright appeal on the mandatory license question. We were there to speak about fair dealing.
Okay, all of that in 5 minutes. So not a lot of time to make your case, but I know that you did it well.
Lots of editing.
There's got to be. There's just not a lot. There's not a lot of time. You got to really focus on the core issues that matter the most. I want to come back to what the court had to say on guidelines, because it does make an important reference to guidelines. But why don't we quickly go through what the court had to say? As mentioned off the top, they come back with the decision very, very quickly. It's typically the average is usually 6 months. This comes back in just over 2.
Mm-hmm.
How did the court address the couple of key issues? First, on, I know you didn't participate specifically or intervene specifically on the mandatory tariff issue, but what did the court have to say on that?
Well, again, Professor Katz really deserves a lot of credit there. The court relied heavily on his scholarship, and in fact, the day that I read the case, I just emailed Ariel right away, and I said, it must be incredibly gratifying to see your words used in the resulting reasons. It really focused on that question that, essentially, if a party that chose not to be bound by the tariff, by a collective license, didn't want to participate in that process, nothing in the way that the collective society provisions of the Licensing Act, even the board certification, nothing could require that or have that tariff or license forced upon a party. And it almost makes some sense when you think about it, and stepping back of the unintended consequences of that ruling had that not happened. And it really, the court went into great depth on the legislative history, the legislative purpose of those collective licensing, collective society provisions, and really did just affirm that they are not mandatory on someone who just happens to copy something in their repertoire. And they pointed to what could be triggered, the enormous fees that could be triggered by one piece of copying that might have been offside.
How did the court grapple with the fair dealing issue?
Yes, so that was the interesting question from our perspective. Obviously, we participated in that, but also because there were some persuasive arguments that fair dealing didn't really exist as a question to be litigated in this case at this point if the tariff were voluntary. It was interesting to me that the court agreed with that perspective, but found it necessary to correct errors of law by both courts below. And one of the great errors of law that actually was gratifying to us, the Canadian Association of Law Libraries, gratifying to read the court write about, was the lack of emphasis or the insufficient emphasis on the end user perspective of fair dealing, again, as interpreted by CCH. And it was, they really affirmed the court's own prior jurisprudence on this question, that fair dealing is a user's right. And in the context of institutional copying, you can't ignore the institution's activities, but at the same time, you cannot ignore the ultimate purpose of fair dealing. And so it corrected some errors of the court below in terms of the application of that test. And I think that was really sort of the ultimate outcome of their reasons, is reiterating the user rights perspective.
Yeah, it definitely is a really strong affirmation of what we've seen in the prior case law. In some ways, it's frustrating a little bit to see the same issues get relitigated and questioned again and again in the court, despite the fact that we've seen a significant turnover in the court. There was no member of the court from CCH still on this decision, but the consistency, I think, over now,
that's right,
more than 15 years is quite remarkable. And it's quite clear that this is where the court is, and that has run through many different judges, and they haven't wavered really at all. You focused, as you mentioned, on the guidelines issue. How did the court highlight the issue of guidelines in the decision? So
on the question of guidelines, so again, the court didn't go into depth on fair dealing. They didn't feel that they had the proper factual matrix anymore, or the proper arguments, the proper parties weren't before it. Again, Access Copyright not having a right to litigate on behalf of a copyright owner. However, it did get into this important question of addressing whether there were serious errors that could not really stand on the record. And I'm again gratified that they did that. I'm also gratified that they spoke about guidelines, even though they didn't speak at great length about fair dealing at all, but did recognize that guidelines as one factor that had been set out in CCH, it remains a relevant factor, and so that was important to the Canadian Association of Law Libraries to see, as well as I'm sure to many in the educational sector. Yeah,
precisely. I think its value really extends to many because, of course, just given the importance of that user right of fair dealing, guidelines become an important way that gets implemented for so many. Mm-hmm. What were your thoughts broadly on the decision? Were you surprised either by the speed or the outcome, or any other aspects of the decision?
Definitely surprised by the speed. I was pleased by it, but I was definitely surprised. and I thought the reasons were authored by Justice Abella, and I'm glad that she invested the time into that before she steps down from the court. But I'm not surprised by the decision on the voluntary versus mandatory tariff. I had read Ariel's scholarship, and I had thought about that question, and Justice Abella did go on at length again about the history of licensing and the emergence of that as a legislative avenue for permissions. She went into great depth on that, and I think honestly, anyone who steps back from the situation and looks at it from the perspective of what it could mean for licensing generally, to have somebody have a license, the terms of a license, which is really what the tariff is, forced upon them when they're not necessarily even aware of it. And, as someone who has worked in a library that was for a time covered by Access Copyright's license, to even delve into the repertoire and discover which works are part of the repertoire is a great challenge. And that's for someone who actually knows about it. So, stepping back, it seems like the most reasonable outcome. And I tend to find that the court's decisions tend toward reasonable outcomes in practice.
Yeah, I think that's certainly, unsurprisingly, I agree with you. I mean, it just never made sense to me to say that someone would be forced into a license in the way that Access Copyright envisioned or argued that the law functioned. And it was good to see the court pick up on that. There'll be, of course, a lot of discussion coming out of this on what this means more broadly for education, educational copying. We've now had multiple decisions that have all gone in the same direction. Do you have a sense of, or an expectation, or even a guess as to where things may be headed now? Is this kind of the end, or is Access Copyright likely to continue to find either avenues with respect to lobbying or even further litigation possible?
Well, I have no crystal ball, but I don't think the story is quite done. And one of the reasons I say that is the intersection of the educational copying provisions of the 2012 amendments with fair dealing was not actually part of this case. The fair dealing question was not evaluated by the court, by the Supreme Court. They corrected errors, but they didn't get into analysis of the case because the proper parties weren't before it. There was no owner of copyright before it for there to give rise to an infringement action that fair dealing could serve as a defense for. So will there be another case? I would say probably it, and perhaps a class action, perhaps a similar kind of context to CCH, where there may be some publishers or some copyright owners put forward as a representative author or copyright holder to test these questions. That's one possibility. It is really hard to say, and as far as Access Copyright's future, that may be an option. They may be able to reform themselves again for the modern educational institution. Again, they emerged from Can Copy, which was really very paper focused, and they morphed into something that dealt heavily with course packs and that kind of bulk copying. So perhaps they will morph into something else that may represent authors directly. I'm really not certain what their goals are, but I think it's pretty hard for them to be a viable collective society, except perhaps for smaller institutions that may not have the resources to invest in ensuring copying is done on side of copyright law, or who may not be subscribing to many licenses to acquire resources through other means.
Yeah, so of limited value for especially many of the larger institutions that are also potentially the source of the largest amount of revenue, who it feels like have in many ways moved on. It's just the marketplace has emerged to allow for more efficient, effective licensing that results in payment, but just not payment through the access copyright intermediary.
And it is true, again, as someone who manages a law library and sees our budget and manages our budget, we pay enormous amounts for educational materials that we provide to students. And a whole separate arena has developed under this. We use learning management systems to ensure that copying, reproduction, and links to licensed material are provided only for the strict purposes of learning and teaching in the classroom, whether it's in a virtual classroom, as many schools did this past year, or whether it's in an in-person classroom. Mechanisms have been adopted to ensure that that copyright holders are getting compensated, and they're getting compensated quite a lot. So the other thing that's changed, of course, is that in this time, fair dealing has come a long way. Those responsible for making decisions about fair dealing are much more informed than they used to be. Even York's own guidelines have changed, and a lot of work, a lot of time and resources and legal knowledge is going into developing those guidelines. Even Professor Katz held a symposium back in 2012, I think it was, where guidelines were, it was a workshop in some ways. It was an opportunity for those who work in this area to share ideas and think about ideas about what should be fair, what could be fair. And that one had the opportunity of the 2012 amendments to look at and adapt guidelines to.
So things have come a long way, both in the courts and within the education community. And I guess these issues are going to continue, but it's certainly been moving, I think, in one direction, one of greater choice and an emphasis over fair dealing, something that's been recognized both by politicians, of course, and now also by the Supreme Court yet again.
Yet again. And guidelines yet again.
Yeah, fair enough. True enough. Kim, thanks so much for joining me on the podcast.
Oh, you're most welcome. It was my pleasure, Michael.
That's the Law Bites podcast for this week. If you have comments, suggestions, or other feedback, write to lawbites@pobox.com. Follow the podcast on Twitter @LawBitesPod or Michael Geist @mgeist. You can download the latest episodes from my website at michaelgeist.ca or subscribe via RSS at Apple Podcast, Google, or Spotify. The Law Bites podcast is produced by Gerardo Lebron Laboy. Music by the Laboy brothers, Gerardo and Jose Lebron Laboy. Credit information for the clips featured in this podcast can be found in the show notes for this episode at michaelgeist.ca. I'm Michael Geist. Thanks for listening, and see you next time.